Go ahead. We're going to take our first call today, and as it happens, it is about sexual harassment, and I know that this is one of your areas of expertise, Travis, so let's go ahead and let's go to Katie. Katie, you're on News Talk WDBO. Go ahead.
Hi, Tom.
Hey, Katie.
I feel like I'm being harassed, and I just wanted to have some advice on that.
Well, Katie, I guess we would need to ask you so we all know a little bit about what's going on at the workplace for you.
Okay. Well, there's a coworker of mine. He started making comments about how he thinks a certain part of my body is awesome. I've tried to ignore him, but he started being more aggressive with the comments about what he wants to do to me specifically. I've told him I'm married, I'm just not interested, but he's persistent, and last week he ended up kissing me on the cheek and said how great I smelled.
Well, then, just out of curiosity, we know, and then we'll get an answer from Travis Hollifield. Katie, is this a superior to you, or is this just an equal co-worker with you?
No, he's just an equal coworker.
Okay. So, folks, for today, my guest today is attorney Travis Hollifield. He focuses on women in the workplace, sexual harassment. What do you think about Katie's situation, Travis?
Well, Tom, and hi, Katie. How are you? This is Travis.
Hi, Travis.
Hey, sexual harassment is basically there's two types of sexual harassment. There's one thing that's called a quid pro quo sexual harassment, which is a Latin term meaning something for something. Basically, what that means is that either a co-employee or supervisor is asking for some type of sexual favor in exchange for a benefit of employment or continued employment or advancement in employment. What it sounds like you're describing could fall into the category of what we call a hostile work environment sexual harassment claim. And in order for those claims to be actionable, the current prevailing legal standard is that you would have to show that if there's one incident of impropriety in the workplace, that it would have to be sufficiently severe for a reasonable person to believe that there was harassment that took place. Alternatively, if there is more than one severe instance of harassment, that can meet the second prong of the legal test, which is whether or not the harassment is pervasive in the workplace. And if this individual who's been making comments about your body being, sounds like very flirtatious with you and obviously kissing you in the workplace, certainly that could rise to the level of being a pervasive hostile work environment standard.
And so what do you recommend for Katie, Travis? If she was your client, if she came to see you, what would you tell her to do?
Well, Katie, first of all, I don't know if your company has an employee handbook. If it does, the very first thing you should do is look to see if they have an anti-harassment, anti-discrimination, anti-retaliation policy. If they do, they typically, not always, but typically will have a reporting procedure. And it's very important for you and for anybody that has a potential sexual harassment claim to seriously consider making a formal report through the mechanism that the employer has set up. There's kind of a complicated legal reason why that's important, but the bottom line is that a report should be made.
Okay, so I'm going to let a lot of people out there work for smallish companies. They probably don't have the workplace booklet like you're speaking about. But just out of curiosity, if Katie makes a report about this, and let's say it doesn't go away, at the end of the day, is Katie going to be suing the employee who is doing this to her, or is she going to be suing the employer?
Under the facts that Katie just brought to our attention, it could be both. Sexual harassment is considered a form of gender discrimination, and the statutes that prohibit sexual harassment in the workplace typically sets up a situation where the defendant, the person who we would be suing, if it ever came to that, is the employer itself, the corporation, the limited liability company, however that business entity is organized. However, in Katie's incident, it sounds like she was inappropriately kissed. It was against her will. She didn't want to be touched by that individual, and that can give rise to what's known as a common law battery claim that can be brought directly against the perpetrator, the individual who touched her without her permission.
Well, certainly before she could ever sue the employer where this is happening, certainly they would have to put the employer on notice first. Would you say?
Well, yes. Definitely in the case of if there's a published employee handbook that requires or requests that the employee follow a reporting procedure. The whole idea is to allow the employer an opportunity at least to address the issue internally, and if they do, hopefully the problem will be solved. But if not, then we would move to a little bit more of an aggressive approach, and that would be, of course, either notifying the employer through competent employment counsel or filing a charge of discrimination either with the Equal Employment Opportunity Commission, which is a federal agency that investigates these claims, or the Florida Commission on Human Relations, also known as the FCHR, which is the state version of the same type of agency that investigates these claims.
Hey,